We're going to call you up one case at a time. So landlords on this side, tenants on this side. As with all cases, the landlord will speak first and tell me what they want. These are all cases for eviction. And in these cases, the landlord is seeking possession and probably unpaid rent. The tenant is seeking something else. I will make a ruling not based on anything I've pre-decided. I will make a ruling based on what is presented by the litigants. We are calling, so this is Harris County, Precinct 9, Place 1. And we're calling case number 2391-00001001. Would the landlord come forward, please, and the tenant. Go ahead and present your case, please.
Your Honor, I'm here seeking an eviction for the tenant. Notice to vacate was posted on their door on September 3rd. We had a 6-month lease that went from January 1st to June 30th. And then they decided to stay in the property, so we went to a month-to-month tenancy that was accepted until around the middle of August, when my agent who was out there noticed that there was an unauthorized dog on the property. So we gave them notice of default for the dog on August 17th. We gave them 14 days to cure that, to remove the dog from the premises. On September 3rd, the dog was still there, and so notice to vacate was posted. In addition, it was added that rent had not been paid for the month of September that was due on September 1st. That was also included on the notice to vacate. And then, I apologize, partial rent for September and full rent for October due 1st, which is $1,000, so $1,500 total.
Okay.
My dog, it's a service dog, conform to FHA. You are not allowed to kick my dog out because it's a service animal, and I have a letter from the doctor saying that I need to have the dog.
If I could, if you could direct all of your testimony to me and not to the landlord, please. Okay. Thank you, thank you. So you're saying that the unauthorized dog is authorized?
Yes,
and
yes, by the doctor.
Do you have any proof of that?
Yes, I have a letter from the doctor.
Okay. Have you shown that letter to your landlord?
Yes.
Okay. So with regard to the rent, she claims that you failed to pay rent in the month of September. Is that true?
I paid $500 on 1st of September. I had some problems, and I tried to pay her $500 on the 10th of September, but she did not. She refused to take the money.
And is that still the case? You're not interested in accepting the money, even though she tendered it later in the month of September?
I am not, because as the notice of default was given for the animal, I actually saw the notice she gave me, which the doctor noticed it was an emotional support animal and not a service animal. But when I checked with my insurance company, her pit bull is a banned breed. And so if I accepted that dog on the property, they would cancel my insurance. And I called around, and a couple other insurance companies, they will not insure that property with a tenant that has a dangerous breed. And so if that were the case, then my bank would call my mortgage due, and that would cause an undue burden. So at this point, it's not about the rent, it's about the fact that this animal, I'm not able to keep this animal on my property without causing a burden.
Okay. You mentioned that you posted the notice on the door. Describe that posting, please.
Well, in addition to sending it certified mail, we posted it on the inside of the front door. We were able to, since we have a key to the property, we opened the front door, knocked, let them know we were coming, posted that in the inside of the property. At that point, the dog was contained in the backyard, so we felt comfortable posting that notice on inside the door.
Okay. Defendant, do you have anything more to add?
No.
Okay. So in this case, I'm going to find that the issue of the unauthorized dog, I'm going to hold is not effective for purposes of eviction. I'm going to find that the tenant did have authorization to have the dog, despite what you're mentioning about the insurance, because I don't see any of that insurance communication in front of me in my case file. I understand that you had these conversations, but that would amount to hearsay. And so I will not accept that as evidence. She has presented the fact of a letter that you have agreed that you received. Whether it's a service animal or an ESA, it doesn't matter. However, I am going to find in favor of the plaintiff because in this case, there was a matter of unpaid rent and a notice to vacate was delivered on September 3rd. On that basis, I believe that the tenant did have a duty to vacate, but because you did not, I'm going to award $1,500 in unpaid rent, possession in 6 days. You are both dismissed.
Thank you.
Thank you.
Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Landlord on this side, tenant on this side. Case number 1003. Please approach. So as with all cases, the landlord will speak first. Plaintiff, please present your case.
Good morning, Judge. I have a signed lease from the tenant here. It's from January 1st of this year. It expires for 1 year, December 31st. The tenant has not paid since July 28th. I have a balance due of $1,200. He's been arrested recently for a domestic dispute with a partner. The partner is now living at the property, but it's not on my lease. I mailed a notice to vacate on September 13th of this year, but the tenant was incarcerated at the time of the notice. I'm seeking possession of the property and back rent.
So far you've testified to $1,200 in unpaid rent. Is that your unpaid total?
Yes, sir.
Defendant, let me know what you have to say in response.
Your Honor, yes, I've been through some hard times. As he stated, I've been arrested because of some problems with my partner. I was trying to add my partner on the lease, but he would not agree to that. So, yeah, now we are still trying to fix that before I can pay rent. If he accepts my partner, I will be willing to pay all my back rent, but I'll have to have my partner with me in the property. And also, I want to state that when the notice to vacate was sent, I was not at home because I was incarcerated. So I did not know about all this process in a timely manner to take action about it.
Okay. Well, I'm going to find that the notice was proper. The fact that you were not on the premises does not affect what the law says about the notice because the landlord delivered the notice to the property by the mail, and I find that that was done properly. I'm going to deem that that notice was appropriate. I do have a question. You brought up the lease and you brought up your partner. I've reviewed that lease because it was submitted as an exhibit, and I'm confused, plaintiff. The landlord on the lease is clearly landlord 3, but the landlord in this petition is property manager. Which party actually is the landlord to the lease in question?
The property manager.
Okay, well, if that's the case, then this lease is invalid. So are you telling me you're presenting an invalid lease or that you filed inappropriately?
I am filed inappropriately.
And I'm finding that that's the case. Unfortunately, because the wrong party filed this petition, only landlord 3 would have standing to bring this case against this tenant. For as much as they owe in unpaid rent and the fact that notice was properly sent, I unfortunately cannot find in favor of property manager because in this case, they're the wrong party. So in this particular matter, I'm finding in favor of the defendant and that the plaintiff take nothing. This case is over.
Thank you, Your Honor.
Judge.
Court calls case 1001, and if the plaintiff will go ahead and state their case and ask what it is they are interested in.
Okay, I'm interested in $7,000. My mother didn't pay in April and May. Then she paid $5,000. The rent was $2,000, so she was half a month's rent behind. And then I gave her a notice to vacate by mail on September 27th because she wouldn't answer at family dinner. Then she has moved out, but she still holds the keys, and there's still personal property in the house.
Anything else?
That's it.
On what date did she move out?
The tenant moved out on September 10th.
What do you have to say in response to what is presented by the plaintiff here?
I paid you. I don't know what you're talking about.
Tell me, so you're saying that in fact you've paid all of the rent and you do not owe the rent?
I don't believe so.
Well, it's not a matter of belief, it's a matter of what you can prove. Can you prove that you have paid all the rent and that his claims to unpaid rent are not true?
I gave it to him in cash, so I can't prove.
Okay.
He didn't give me a receipt.
He didn't give you a receipt. All right. Let me ask some questions of the plaintiff then. Mr. Plaintiff, is it true that you accepted payment in cash at any time during the pendency of this lease?
No, I did not.
Okay. In what form were payments received?
She sent it by Zelle.
Sent it by Zelle. Ms. Tennant, did you at any time ever submit payment to the plaintiff for rent through Zelle?
No, just cash.
Cash
I gave it to him
only?
in cash, yes.
Okay. Landlord, do you have any evidence that any of the payments were ever received by Zelle?
Yes, all the Zelle payments into my bank account, on my bank statements.
Okay. And can you produce those to the court?
Yes, on my phone.
All right. I want to talk about this notice to vacate. Did you in fact receive this notice to vacate?
Yes, I did.
You had already vacated or you left the property on the 10th, is that right?
Correct.
Is it true that you left your personal property on the premises and have not removed it?
Some, yes.
Okay. Well, in this case, I'm going to find in favor of the plaintiff because I can show that through the testimony evidence, I find the plaintiff's testimony convincing that money was received at certain points through Zelle. I find the tenant's testimony unconvincing that she never submitted money through Zelle when the plaintiff was able to demonstrate with evidence. And so I'm going to find in favor of the plaintiff in the amount of $7,000, possession in 6 days. This case is closed.
So do I have to move all my stuff out?
That's a matter that you can discuss with legal counsel. Unfortunately, I'm unable to give you legal counsel. What I can tell you is that if this case is not appealed in the next 6 days, you may have to deal with a writ of possession in which your things will be forcibly removed. I strongly suggest that you speak to legal counsel about your legal options at this time. Thank you. You are both dismissed. The court now calls case 1004 to the bench. Landlord on this side, tenant on this side, please. Plaintiff, this is your case. Go ahead and let me know what you'd like from the court.
Yes, I'm requesting possession. I have not received September's rent. I issued I handed them on September 5th a notice to vacate because September rent was not paid. The tenant tried to bring October's rent to me, but I'm not going to accept it because on July 31st, I actually handed them a 30-day notice to terminate the lease.
Well, is there anything else?
No.
So what I'm hearing then is $1,500 is owed from the month of September.
Yep.
And you're asking for another $15 for the month of October.
Correct.
All right, Ms. Tennant, go ahead and let me know what it is you have to say about your defense.
So I did pay September. I've always paid on time. I've always paid you cash. And we talked about it. And your lease says I can pay you in an app. And I told you in September I was going to use the Cash app. And then my phone died. And if you send your phone, Apple won't give you back your phone in time. So I couldn't show him. I had to go through, submit my security information. And I had to go wait for 30 days. And so I couldn't even get my phone back to show that I paid by cash. But I always pay by cash. And then I tried to pay again in October. And he wouldn't accept my cash.
Please direct your comments
He would
to
not
me.
accept my cash, Your Honor.
Okay.
In October.
All right. Plaintiff, is it true that you have previously accepted cash payments?
Yeah, I accept cash. It's just September. She didn't bring any.
Okay. Do you have a copy of your rent ledger from those cash payments?
I take pictures when she gives me the cash, and I don't have a picture in September.
Do you produce a receipt whenever you take a cash payment?
No.
All right. Tenant, the plaintiff testifies that on July 31st, 2023, he delivered a notice of termination. Do you recall receiving that notice?
Yes, I did.
Well, I'm going to give you an
I
opportunity
know.
to
Yes,
correct
I
your
did,
testimony.
sir. It was just a lot going on that time.
I understand. I
There's a
understand.
lot going on.
And I've reviewed your lease.
But
and
sir, it does say that I can pay in cash on the lease. It says back here.
I've taken your testimony. I clearly understand, and I've noted that fact. What I am looking at is that your lease did, in fact, have a lease termination date of December 31st, 2022. So it appears that your lease did go on a month-to-month basis, and that on July 31st of this year, the landlord did deliver notice of termination. So the rent payment aside, why wouldn't the plaintiff be entitled to possession on September 5th when he sent that notice to vacate, just based on the termination alone?
Well, we talked and he kept taking my money, so I thought we were good. He took my August payment.
But isn't it true that you owed August?
No, I paid August.
Uh-huh.
And I paid September. I've never been late. I'm a good tenant, Your Honor. I'm honest.
Well, I'm not going to make a judgment as to whether you're a good tenant or whether you are honest. I'm making a judgment on whether I believe that this particular landlord has proven his case. Now, what I can find is that, in fact, the notice to vacate was delivered on September 5th, and that whether it was based on non-payment of rent or whether it was based on the termination, I believe it was valid. Mm-hmm. What I'm also going to find, because Chapter 92.011 of the Texas Property Code requires a landlord to maintain a ledger and to establish a receipt for every cash payment he accepts, that because that has not happened, that your proof with regard to payment or non-payment is insufficient. So in today's case, I'm going to rule in favor of the landlord for possession only, and that the issue of rent has not been established by the landlord. You have possession in 6 days, but no rent is due. If you plan to appeal, you have 6 days to do that. Otherwise, you're required to vacate. That is my ruling. Case is closed. All right, we got the last case on this morning's docket. It is 1005. Will the landlord and the tenant in case 1005 please approach the bench? All right, this is the plaintiff's case. Go ahead and present your case.
So, Your Honor, the tenant has not paid rent for the month of July, August, September, and October. The lease does not allow a pet on the property, but the tenant has a unauthorized pet living in the property. Also, subletting is not allowed on the property, on the lease. Tenant is listing a room for rent on Airbnb. And also, I had to walk in on the property one day, and she filed a police report on me because, saying I didn't give enough notice. So that's what's going on at this moment.
So let's talk about that unpaid rent. What is the monthly rent owed?
It's $1,500 per month.
So for 4 unpaid months, are you asking for $6,000?
Correct.
And how did you deliver that notice to vacate?
I posted it on the door in person.
You posted on the door in person. Tell me a little bit more about how you did that.
So I went over there. I posted it on the door, and I have a picture snapped. So it's time-stamped that I delivered it on the door.
Okay.
I knocked on the door, but nobody answered. So I couldn't get inside or leave it in the mailbox or anything.
So then you affixed the notice to the outside of the door.
Correct. On the front door.
Ma'am, would you go ahead and like to present your case and what defense you have to the statements you've just heard?
Your Honor, good morning. First of all, I never found any notice in my door. He's mentioned about the pet, but I found a very poor pet in the street, and in the contract doesn't mention anything about the pet, so I carry to my home to take care of him. And about Airbnb is because I lost my job, so a way to try to to get a little bit of money, I rent a room in Airbnb.
Okay. Is there anything else?
Yeah, the AC, it doesn't work, and it's very hot, and I request many times, but he never answered me, and that he entered in my home without permission, and I called the police.
So when did the issue with the police happen?
When he tried to enter in my house.
Do you know why he was there? Did you say he gave you zero notice of going in?
Zero.
Okay. Is this accurate that you tried to enter without any notice?
I tried contacting her. She never responded, so I had to walk onto the property.
When you say you tried contacting her, what do you mean?
On the cell phone, I called her multiple times. She wouldn't pick up.
Okay. All right. And that's the only way you attempted to notify her?
Correct.
So I briefly looked over your lease, and I do see that in your lease, Section 8, entry and inspection. The landlord may enter the property at reasonable times and upon reasonable notice to the tenant to make repairs or conduct inspections. So I don't know that just making a phone call is enough. Especially, I heard your testimony. You didn't say anything about leaving a message. You didn't say you sent her a text. You didn't say you sent her an email or a letter or some reasonable notice. Your lease requires reasonable notice, and so I'm going to find that there was no notice. If there's an issue with the police, that's between you both with regard to that. I don't think that changes the case. I am worried about two other things. I don't know that you have a defense for the non-payment of rent. You owe the rent. You didn't give any testimony that the 4 months of rent was actually paid. So it's my determination that the $6,000 is validly owed. The problem with this case, however, is if you posted the notice to vacate on the outside of the door, that's insufficient for this court. The Chapter 24 of the Texas Property Code requires that if you're going to post it on the outside of the door, you have to put it in a sealed envelope. You have to write the tenant's name on the outside. You have to write in bold print, important document, and then the same day by 5 p.m., you also have to mail it to them. I heard no testimony that any of those things actually happened. And because of that, I'm going to find that the notice itself was insufficient. Additionally, because I reviewed the lease, I see that there are 3 tenants who signed this lease. Is that accurate?
Yes.
Well, I see in your petition that only one tenant, this tenant, was sued. In a case for eviction, it is absolutely necessary that all the tenants who signed the lease who remain in possession are included in the lawsuit. And so I don't know if those people are still in possession or not. I don't even think we need to get to that point. In this matter, I'm going to go ahead and dismiss the case for insufficient notice. Remember that if you're going to post it on the outside, you have to follow all of the rules of Chapter 24 or find some other method of delivery. In this case, I'm going to go ahead and dismiss. You are both free to go. Case is dismissed.
Thank you.
Thank you.
Thank you.